This is Foundations of Property Law, and I believe we're up to week 10. So tonight we're dealing with material relating to topic number 8 and acquisition of property rights. So the second last substantive topic for the unit. This week is also what I've described as feedback week. And you would have noticed on the Moodle site, the big red button on the top right-hand corner, have your say. And one student has already had their say, thank you very much. I would ask that 50% or more of the enrolled students, please have your say. And if there's anything you'd like to discuss in tonight's session regarding feedback, or in the Q&A facility, or even just an email to me, please do so. So feedback is important for the university. It's important for me as well. I am keen to receive feedback in relation to this unit, to the assessment regime, and it may be that you've got issues of feedback for the unit, for the course as a whole. So the objective for me is to ensure that I provide you with the basic material to allow you to undertake your own study, develop your own skills and methodology in relation to the foundations of property law content. So there has been a very consistently good cohort of students engaging in the unit, and I do appreciate that. For those of you that are not able to attend the live session, remember we've got 2 more weeks, so we'd love to see you. So feedback week, please have a look at that. The next thing that I want to mention briefly before we deal with the substantive issue is that of ethics. And ethics is very important in your professional life, starting now as students. And your role as being an advisor is something that's important to consider as well. You need to consider, within the context of any dispute that you may become involved in, that restraint is important and cooperation and sound judgment are important as well. And this all comes back to your role of being ethical, and remember, of course, that being ethical is a specific threshold learning outcome. So knowledge, for example, is one of them, research skills, communication skills, ethical skills as well. And threshold learning outcome number 2 deals with ethics and professional responsibility. So whenever you're considering a question in the context of writing a response to something presented to you, please do consider ethics and professional responsibility. And there's a wide range of areas that you can draw information from to assist you in that process. An excellent resource, one that I may have mentioned, but certainly I do want you to have a second look if you've already been there, is the Queensland Law Society Ethics Centre. It's an excellent resource and it contains a lot of information that will help you in terms of understanding your role and answering legal questions. Of course, you need to consider the Australian Solicitors' Conduct Rules and also the Barristers' Rule in the context of Queensland practice. Consider the Legal Services Commissioner website, because that's also very valuable. And on QCAT website, you'll see a lot of decisions about where things have gone wrong and professionals have been prosecuted in relation to their role, and the question of whether action should be taken against their practicing certificate is considered in a wide range of cases. In order to fulfil your duty, you need to know what that duty is. And you would probably need to look at, say, the Australian Solicitors' Conduct Rules. There are some rules that are particularly relevant. For example, 3.1 talks about your duty to the court, and this is very important. The role of an advisor is to the administration of justice as being paramount, which supersedes your obligations to your clients. Remember, of course, that if as a practitioner you give an undertaking, then you must honour that undertaking, and you're under an obligation not to deceive or knowingly or recklessly mislead the court. People forget about the recklessness. So if you're asked a question and you don't know the answer, then as a general rule in court, don't guess. Concede the fact that you don't know. Certainly offer to find out if that's relevant. Now, when it comes to providing advice to clients and considering the way in which a legal problem might need to be resolved, remember, of course, that you now, these days, need to take a holistic view of your clients' concerns and their problems. So that was not the case when I commenced law, studying law in the 70s. When I talk about taking a holistic approach, I'm really saying that you need to consider all of the circumstances that relate to your client, and it's not just a simple exchange of instructions and advice, that you need to go in a broader fashion for that. One specific example is that you may need to consider non-adversarial ways of assisting your client to resolve the dispute. In the old days, it was pretty simple. Someone came in, outlined the problem, and then you essentially fulfilled the IRAC obligations or methodology and issued proceedings, and then we may discuss resolution of the matter on the doorstep of the court, so to speak. And the parties, the plaintiff and the defendant, ran down parallel tracks until we got to the court hearing. But we don't look at things that way now. You need to take this holistic approach and you need to consider alternate ways of resolving. Do consider taking alternative dispute resolution as a unit. It's a second term unit and it's very good. It's an elective. Now, for professional ethics, as I mentioned, consider the practice rules. Also consider some of the specifics. For example, in the Australian Solicitors Conduct Rules, I've mentioned Rule 3 is important, but have a look at Rules 3, 4, 5 and 6, which deal with the fundamental duties. Now, that can be important when it comes to answering a question, because if you have that as a ready reference, you may, in trying to answer the question, have recourse to what are the fundamental duties of a solicitor, and that may help you in some way. Have a look at Rules 7 through 16 inclusive for the relationship with clients. Advocacy and litigation, and I've touched on that, is Rules 17 to 29 inclusive. And for example, Rule 21.2 is important in the context of litigation and disputes generally, because it provides that a solicitor must take care to ensure that the decisions by the solicitor to make allegations or suggestions under privilege against any person are reasonably justified and are appropriate for the robust advancement of the client's case and are not made primarily to harass or embarrass another person. People sometimes forget that. So if you make some form of allegation or suggestion in a legal answer, even at university level, you may run foul of the obligations in Rule 21.2. For barristers, different set of rules. The Barristers Rule 2006 or 2016, as it's amended. Have a look for advocacy rules 12 to 14. The rules relating to duty to the court 25 to 36. To the client 37 to 40. And the responsible use of court process 59 to 67. In the website in Moodle, I believe I've referred you to a video, myself and Judge Dean Morzone, QC. If you haven't had an opportunity to look at that, I urge you to do so, because His Honour was remarkably generous with his time. This was just before he was took oath as a judge, when he was a practicing QC. And speaking of judges and the bench, have a look at the bench books. If you haven't looked at bench books, they're a very valuable resource, particularly in the context of litigation. So, for example, if you're dealing with criminal law, then you'd certainly want to look at the bench books, because that provides a lot of answers to questions of how to describe something. And the reason that they're very authoritative is they are the actual documents that many judges and magistrates use in practice in explaining concepts or applying the law. So bench books, there's a whole range of different bench books for different jurisdiction. Keep that in mind, might help you immensely in your course, in the law degree, and also in practice. If you do end up in practice, remember, of course, the Queensland Law Society, the material that's there, and consider some wider issues such as guidance statements that the Law Society provides. One thing that is often overlooked and not mentioned at this undergraduate type level is issues around capacity. So when you're developing your checklists, your procedures, your flow charts, the things that you need to consider as preliminary issues, I've already mentioned ethical issues as being important. Another is just to keep in mind the question of whether your client truly has the capacity to provide appropriate instructions. So a good definition of what we mean by capacity is in the Guardianship and Administration Act 2000, that's Queensland. Have a look at Schedule 4 and you'll see the definition of capacity. All right, so that's just some preliminary comments of a more general nature. Now, are there any questions about what I've discussed so far before we consider issues around acquisition of property rights?
John, how do you get your hands on bench books?
They're on the internet.
Okay.
And I may have included a reference to the bench books in additional resources, but if I haven't, if you Google bench books Queensland, you'll find them pretty easily. You should find them probably in the court's website or the Supreme Court Library website as well.
I just Googled while we were talking when you mentioned them. So they do sound interesting, and I just downloaded a PDF straight away, so very easy.
So you found them easily. Thank you, Carolyn. Excellent. All right, good. So, acquisition of property rights. Now, tonight we're talking about the acquisition of property rights in relation to both goods and land. And we deal to some degree with the formalities of the transfer of land. So we'll look at the general law, the Property Law Act. We'll look at some compliance issues, particularly relevant to real estate. And for a more detailed analysis of this area, the conveyancing unit, conveyancing laws 12059, I think, is an excellent course. Again, it's an elective, so one that you might consider because it's really very practical. So, of course, when someone signs a contract either to sell or buy, interests are created as a result of that. And generally, until such time as the registration process occurs, and I'm talking about real estate now, the interest held by the party as a buyer, for example, as we discussed last week, is essentially equitable. And we'll be talking more about equitable interests next week and contrasting that to common law interests. Also in the material, there's some reference to gifts in the context of land and also express trusts, or which are regulated by the Property Law Act. So when it comes to dealing with this topic, there are a wide range of matters that you need to consider. And the reading material is very good, but I'm going to try to supplement that, and as I often do, direct your attention to the primary sources of the law, because to my mind, sometimes and very often, the primary sources of the law are actually a bit easier to read and they're much more direct. So if you read the primary sources of the law, you can then use the secondary sources more as a checklist, clarification, provision of examples, but go to the primary sources wherever you can first up. So to start that discussion, let's have a look at the Property Law Act 1974, Queensland. Very important piece of legislation. Have a look at Part 2, dealing with general rules affecting property. And bearing in mind, of course, that tonight's topic relates to acquisition of property rights. So when we talk about the general rules affecting property, it obviously has a direct effect on property rights. The first section is Section 10. It relates to assurances of land to be in writing. No assurance of land shall be valid to pass an interest at law unless made by deed or in writing signed by the person making such assurance. You need to look up what we mean by assurance. Where would you think to look up the term assurance? Where are some of the places you'd look? I'll open it up. Yes, Natalie?
Under the definitions?
Yes, definition section within the Act. That's probably where I would look first up. But when you look at Section 10, and I'm looking at Ausley at the moment, I know I shouldn't. I should be looking at the authorised, but I do tend to go to Ausley first up. There's something about the actual font in Section 10 and the word assurance that suggests to me that there's no definition within that Act. I know that's cryptic what I'm saying, but can anyone understand what I'm getting at? Well, here's the answer. Very often in legislation, certainly in Ausley, there are generally hyperlinks. So if a word is defined within the Act, it will normally be the subject of a hyperlink. The word assurance is not. It's not to say that there isn't a definition within the Act, but that's a hint to me that there's no definition there. So if you couldn't find the definition of assurance within the Act, where would you go to look for that definition? Any thoughts?
Could you try the Acts Interpretation Act?
Yes, I like that answer, Tammy. You could try that. And the Acts Interpretation Act, when you're dealing with the interpretation of legislation, should always be there in the back of your mind. It's always got to be part of your checklist, flow chart methodology. Anywhere else that you could look for information about what we mean by the word assurance? I'm just taking it as an example, really. Where else could we look? Dictionary. Yes, Ashley's gone for the obvious one. I thought that might have been the first one. But yes, there's nothing wrong with going to Oxford Dictionary. But is there only one type of dictionary, or do we have a couple of types of dictionary that might assist? Yes, Ivan.
Well, on the Lexis specific, there's a dictionary that defines legal terms,
Yes.
which is useful.
Very good. So a very good legal dictionary is an important resource. So as part of your preparation, you should have your preferred legal dictionary and access to that very quickly. It doesn't have to be in hard copy. As Ivan said, you can access it online. And is there anywhere else that you can think of to give you some indication of what's meant by the word assurance? I'm thinking of a couple more. Relevant case law, Caitlin. Yes, that's one of the two, because often the judges will describe what is meant by these terms. I've got one more. There are more, but I've got one more in mind, and that is by reference to the explanatory note or explanatory memorandum. So again, going back to your statutory interpretation days, you'll know that they're different. That's a range of different sources to assist you in terms of understanding what we mean by something written within the legislation. And again, I know I sound like a broken record, but you should have this documented. You should have it as part of your general checklist, toolkit, whatever you might call it. Have hyperlinks to the Acts, to the dictionary, things of that nature, just to assist you in a practical way. Anyway, coming back on point, Section 10 requires something to be in writing for an assurance of land. And a deed is something different to a contract. Can anyone tell me the difference in general terms between a deed and a contract or an agreement?
A deed doesn't require consideration.
Yes. And it also doesn't require number 5. I think it's the intention to enter into legal relations. I'll have to check that, but certainly consideration is the big one. Thank you. So just remember, no, you better forget what I just said at the end there and go with what Ivan said, consideration. So a deed poll is something which is a deed signed by one person only, but generally deeds are involving 2 or more people. All right, so coming back to assurance, I said before that there's a hint, it's not hyperlinked, so it tells me initially that it probably isn't defined in the Property Law Act, but has anyone actually found the answer, which is within the Property Law Act? So again, another furphy from me. Tanya?
It's in Schedule 6 to the Act.
Thank you very much. You found it. So it's in Schedule 6 and it includes a conveyancer and a disposition made otherwise than by will. I don't know why that one's not hyperlinked because many others are, but you've got to be a bit careful. So thank you. So when we talk about an interest at law, that comes back to a fundamental aspect of property law, doesn't it? Where we talk about a bundle of rights, people having an interest in land as this bundle of rights. So the bundle of rights can be affected one way or the other if we have an assurance which is made by deed or in writing, and will certainly have a difference if it's not by deed or in writing. Now, there are exceptions. So, for example, and this is an important one, if a lease does not satisfy the formal requirements for a legal lease, and again, we'd look at the Property Law Act primarily for that, it may still have the effect of being an equitable lease if a specifically enforceable agreement exists. Now, that's a lot of words, and I'll break that down. So even though there are at times bland statements that appear to provide for no exceptions, remember, of course, that when it comes to the common law and equity, equity will try to find ways around the black letter. Some leases may be equitable leases as opposed to legal leases, and the difference is this. I mentioned that the process of registration of a transfer makes the interest of the buyer legal through registration, as opposed to equitable, which provides for rights to enforce in certain circumstances. So the case that you'd want to consider within the context of an equitable lease is Walsh against Lonsdale. Walsh and Lonsdale, it's 1882, 21 Chancery 9. But, as I mentioned, under statute, an agreement needs some memorandum or note in writing. In Walsh and Lonsdale, briefly, the parties entered into an agreement for lease. The tenant went into possession, started paying rent. The formal lease was never signed, even though it provided for 1 year's rent in advance. And the court held that even though there was no formal lease, equity would enforce the agreement according to its terms, which is a bit like Walton Stores and Marr, if we're thinking about crossing over to a different unit. So the rule in Walsh and Lonsdale applies in the general law, generally speaking. Now, again, another exception is this: the Residential Tenancies and Rooming Accommodation Act, 2008 Queensland, or the Residential Tenancies Act, as we often abbreviate to. Section 27 says that the Property Law Act does not apply to residential tenancy agreements. So we have a different regime for interests in real estate where it relates to a residential tenancy as opposed to, say, in the case of a Property Law Act, a commercial tenancy. And remember, of course, that in addition to the general law relating to commercial leases in the Property Law Act, most of the leases in Queensland are governed by the Retail Shop Leases Act. So we have two pieces of legislation that deal with commercial leases, Property Law Act and Retail Shop Leases Act, and we have one piece of legislation primarily dealing with residential tenancies, the Residential Tenancies and Rooming Accommodation Act, 2008. If you can sense a degree of frustration in my voice, it's because I am frustrated at the unnecessary complexity associated with this. If we had a decent Property Law Act, we could deal with all of this in the one piece of legislation and it would be so much clearer. But if you don't go to the primary sources and have that understood and then understand that, it becomes really confusing if you're trying to read this from the secondary sources. I hope that makes sense. Let's move on to Section 11 of the Property Law Act, which says that instruments are required to be in writing and no interest in land can be created or disposed of except by writing signed by the person creating or conveyancing the same or the person's lawful agent. A counterpart section, one that often goes with Section 11 of the Property Law Act, is Section 59 of the Property Law Act. Now, here's the habit that I've adopted when I notice that two sections seem to be talking about the same sort of thing and they're not next to each other, which begs the question, why? Why aren't they together? Now, I'm not necessarily going to provide an answer here, but I'll give you a hint as to at least my practice. What I do is I then go to the table of contents, and as certainly I've suggested on many occasions, when you start to read legislation, have a look at the general headings first to get a feel for what these individual sections might mean within the context of the relevant part. So Section 11 is in Part 2, General Rules Affecting Property. Section 59 is in Division 3 of Part 6, and Division 3 relates to the sale of land and Part 6 relates to deeds, covenants, instruments and contracts. So a different emphasis, if you like, between the more general Section 11 and the more specific Section 59. Now, I mentioned before that registration of interests is fundamentally important. Remember Bresk, Far and Wall, what we mentioned last week. So registration is important because it creates these legal rights. But not every interest needs to be registered in order to be enforceable, even if it relates to land. So here's another important concept and case from a practical perspective. An unregistered legal lease can be created in Torrens land if it's a short lease and it's protected. And it's protected if it's for a fixed term of 3 years or less. Now that doesn't include the option to renew, but for the original 3 years term or less, it is protected. It's regarded as a legal lease, even if it's not registered. And the case to quote on that is Friedman against Barrett, F-R-I-E-D-M-A-N against Barrett. It's in the Queensland Supreme Court. From memory, it was 1960. All right. Now we're going to switch to the Land Title Act. So if you could please join me by going to Section 184 of the Land Title Act. Section 184 deals with the quality of registered interests. You'll see that in this particular piece of legislation, there's a real emphasis on registration. Think Breskfar and Wall. Because registration is that critical component that, for the most part, equates to the interest holder having a legal as opposed to an equitable interest in property. So we talk about a registered proprietor of an interest in a lot having certain rights, and that relates to the quality of the registered interest. And an interest is more than just ownership. It can be a mortgage, a lease, an easement. It can be all sorts of things. So Section 184 provides for the general quality of the registered interest. But if we look at Section 185, we immediately come across the exceptions to 184. Now again, if you're on the ball here, before you started to read sections 184 and 185, you might have had a moment to go out of those sections, have a look at the table of contents, have a look at the relevant part and the relevant division. And then we can better put these sections in context. So sections 184 and 185 are part of subdivision B of division 2 of part 9. What is subdivision B all about? It's about a very important word. It's a strange word, but it's a word that you really need to document and have a good understanding of, and it's the word indefeasibility. It's a key concept because we talk about indefeasible title, and it's essentially as good as it gets. So an indefeasible interest in fee simple is about as absolute ownership you can get in Queensland. So subdivision B talks about indefeasibility, the rules for indefeasibility. That's within the context of division 2, which talks about the consequences of registration, another key issue. And division 2 is within part 9, which talks about the process involved and the effects of registration of instruments and its effect. You'll need to look at the definition of instrument, but it's essentially document. And it starts by talking about how an instrument is registered, and then it goes on to talk about the effect. Section 178 is really important because it talks about the priority of registered instruments. And we mentioned earlier that on the one title for a particular lot, it's possible for a number of people to have interest in that property, and it's possible for a number of people to have registered instruments, instruments on that title as well. So we need to consider the priority. But indefeasibility is the key term. So have a look at section 184 and then look at the exceptions in 185. If we look at that now in section 185, you'll see that the basic principle is this. A registered proprietor of a lot does not obtain the benefit of section 184 in relation to a number of things. A, an equity arising from the act of the registered proprietor, which brings into play this concept of equitable interests. And B, I've mentioned it already tonight, the interest of a lessee under a short lease. Short lease is 3 years or less, but bear in mind, we're talking here about primarily commercial leases in practical terms, but it also relates to residential tenancies as well. Well, I hope I'm not confusing you, but what I'm looking to do is establish for you some points of reference, key points of reference where you can work around them. So 184,
John,
185 important. Yes, Ivan?
John, just on that paragraph 1B, the interest of a lessee under a short lease. Does this simply mean that if I purchase a property that is occupied by a lessee, I purchase with notice and my property subject to those interests of the lease? Is that correct?
It is. Your voice, at least for me, was breaking up there just a little with bandwidth problems, but I understood what you're saying, and it's a great question, and you're absolutely right. So the general principle is this, that the legal interest held by someone comes about as a result of registration of the instrument that reflects that legal interest. But there are exceptions, and a short-term lease is one of those. And the consequence, absolutely right, Ivan. If you buy a property which is subject to a short lease and you know about it, then even though the short lease is not the subject of a registered instrument, it's not on the title, the holder of that short lease still has better title than you as the registered proprietor of that lot. And we get into grey areas when it's without notice, but the general rule is if you've got a short lease, then you will have that priority if it comes into existence before a competing interest. So thank you, Ivan. Very good question, spot on. Any other questions, comments, concerns? All right, if we look at the Land Title Act Schedule 2, you'll see the definition of short lease. Lease for a term of 3 years or less, or from year to year, or for a shorter period. So if we go back to our table of contents or provisions for the Land Title Act, you'll see from what I've said that Part 9, dealing with registration of instruments and its effects, is very important. So have a look at sections 173 to 179. It deals with the registration process. Division 2 deals with the consequences of that. What is the effect of registration? When does someone have a right to have their interest registered? And for the purpose of this week's study, can I just say that Part 9 is critically important. Please go to that primary source, read that primary source, take it in, and then maybe do some other reading around it. Section 180 talks about the benefits of registration. So it's a key consequence of registration, and it applies whether valuable consideration is given or not. Section 181, an interest in a lot not transferred or created until registration. Now, there's a key word here. If we look at section 181, it says an instrument, so what's an instrument? It's really a document, does not transfer or create an interest in a lot at law until it's registered. And you've heard me say that quite a few times, that it's the process of having the instrument registered that creates the legal interest in the real estate. Until then, you've got an equitable interest. What's your authority for that? If you're standing in front of a court or you're having an argument with another practitioner in a legal dispute, so section 181 says it clearly. You don't have an interest at law until registration. And that's the whole Bresvarin-Wall principle. Registration is important at law. Next week, we'll talk about equity. We'll talk about how equitable principles come into play. But when we're talking about legal title, that's the key, section 181. But note section 71 of the Land Title Act. So we go back to the table of provisions because now I'm bouncing into a section in a different area. So you want to get a feel for what this section, this other area is. So section 1 is Division 2 leases. It talks about the validity of unregistered lease, and it's in part 6 dealing with dealings directly affecting lots. Let's have a look at section 71. What is the validity of an unregistered lease? It goes back to Ivan's question. An unregistered lease of a lot or part of a lot is not invalid merely because it's unregistered. So I mentioned earlier, section 181, an instrument doesn't create a lot at law until it's registered. But then we look at section 71, it says an unregistered lease is not invalid merely because it's unregistered. It's not necessarily saying it's legal or equitable, it's just saying it's not invalid. So you've got to work both ways with this. Section 182. What is the effect of registration on an interest? That's critically important because that's a key issue. And it just generally says that once you've got something registered, then it vests that entitlement in the person who has the benefit of the registration. Who has the benefit? We look at section 183. The right to have an interest registered is referred to in section 183 of the Land Title Act. So if the instrument has to be executed, executed meaning signed, the person lodges the document and the person otherwise complies with the Act in relation to registration. I mean, for example, you've got to pay a filing fee. If you have each of those three things, you have a right to have an interest registered. Section 184 talks about the quality of the registered interest. So a registered proprietor holds the interest subject to a registered interest affecting a lot but free from all other interests. So section 184 is really important because this is the heart, section 184 is the heart of the concept of indefeasibility. So read subsection 1 very carefully. Subsection 2 says that that is not affected by actual or constructive notice of an unregistered interest, leaving aside the exception that we talked about earlier regarding short-term leases. And subsection 3 doesn't apply to an interest mentioned in section 185. So I mentioned short-term lease as an exception. That was one of the exceptions referred to in 185. So you need to sort of work your way through these things. Sorry, it's a bit confusing. Have a look at those exceptions and you'll see there's some examples there as well in relation to, for example, petroleum and gas, and some rules that relate to mortgages. Now, let's move to another piece of legislation, the Sale of Goods Act, Queensland, 1896. So section, well, the starting point for this one, have a look at the long title to the Act. So let's see if I can find it. Sale of Goods Act, 1896. We don't often go to the long title, but it says here, it's an act for codifying the law relating to the sale of goods. Now, bear in mind, this is when it was written, but what do we mean by codification? What's the intent of the legislator if they wish to codify. Any thoughts?
A codification is a codification of the common law.
Yes.
In an act.
In an act, yes.
Yeah.
And essentially the intention is if you've got a code, it's meant to be all embracing. So what I think we should have done in 1974 is I think we should have made a property law code, not a property law act. Do you understand what I'm getting at? So we have the criminal code, which was intended to be a consolidation of all the common law and all the statutes for one all-embracing piece of legislation, same for the Sale of Goods Act. We don't see too many codes, but there are some. So this one was intended to be a code. If we look at the next section, we'll see that it talks about the operation of the Act and then the definitions. Now, I'll just say that when it comes to the interpretation of a code, what we're supposed to do is look at the intent of the language, or the language itself within the statute, and then try to adopt its natural meaning. When we're talking about a code, because it's intended to replace the prior common law, it's not the proper approach to look at what the law was previously and assume that it was meant to be altered or unaltered or whatever it might be. So interpretation of a code is slightly different in its emphasis to the interpretation of a standard act, if I can use that term. So have a look at some of the definitions in section 3. Contract of sale includes an agreement to sell as well as the actual sale. And you'll see there that in OSLI at least there are hyperlinks, meaning that'll take you to a definition. And goods, have a look at the definition of goods because that's quite, that's important to know whether this act applies or not. Then have a look at section 5, which talks about the capacity to buy and sell. And it talks about special rules that apply in relation to necessities or necessary items. And that can have an effect on whether a contract for buying or selling is valid, even though the person is involved is an infant or is mentally incapable. The concept of capacity brings me back to an early comment this evening, that you need to know what we mean, what is the definition of capacity. Have a look at the Guardianship and Administration Act. Then have a look at section 6, which talks about the formalities for the making of a contract for the sale of goods. And you will see there that unlike real estate transactions, a contract for the sale of goods may be made in writing, but it does not have to be made in writing, or it can be by word of mouth, or partly in writing, partly by word of mouth, or it might even be implied from the conduct of the parties. Nothing said, but a customer picks up an item, takes it to a checkout, money changes hands, and people walk out the door. You can see from the conduct of the parties that a contract took place. So ask yourself, if you're answering a legal question, whether, for example, in determining whether a contract existed, was there anything in the conduct of the parties that may have a bearing on the answer? So that's section 6. Have a look at section 8. It talks about existing or future goods. Section 9 deals with goods that have perished. Section 11 talks about ascertainment of price. So the price in a contract might be fixed, or it might be left to be fixed in a manner agreed upon, or it may be determined by the course of dealings between the parties. And when the price is not determined in accordance with any of those things, the buyer must pay a reasonable price. What's reasonable depends on the circumstances. Now, that doesn't apply. We don't have that section in the sale of land, because in land transactions, you need the basic 3 Ps. You need certainty of the parties, you need certainty of the property, and you need certainty of the price. But when it comes to the sale of goods, you don't need to have a fixed price for it to be legally enforceable. It might seem really odd and something we don't come across every day, but the sort of thing that examiners like to put into legal questions because it's a little bit obscure. So keep that in mind. Section 11. Section 13 relates to stipulations as to time. So where there are stipulations in time, you need to consider whether that has a bearing on the contract. And unlike the position for the standard sale of real estate, at least in Queensland, contracts for the sale of goods are not of the essence. Time is not of the essence. So subsection 1 says, unless a different intention appears from the terms of the contract, stipulations as to the time of payment are not deemed to be of the essence of a contract of sale. Those of you that are involved in conveyancing, or if you've bought or sold real estate, you may be aware that there is a standard provision in the contract to say time is of the essence. It means that if settlement is to be effected on 10 June 2020, the general rule is that if the buyer is not ready on 10 June, even though they might be ready on 11 June, near enough is not good enough. The contract was stated as being one where time is of the essence, and 5:01 p.m. on 10 June, in the absence of money from the buyer, the seller would be entitled in a real estate contract using the standard terms to terminate the contract, for example, declare the deposit forfeited, and then resell to somebody else. That type of very strict interpretation does not apply for sale of goods. So you can see that we've got these counterpart systems running where there might be a fundamentally different outcome to the same dispute, depending on whether we're talking real estate, which is covered by the Land Title Act, for example, or sale of goods, which is covered by the Sale of Goods Act. Very confusing. I'm not sure it's necessary to have so many distinctions, but we do have them. Now, some conditions are treated as warranties. Section 14 is important from a practical perspective because it provides that where there's a contract subject to a condition, that may be waived, or it may be elected to treat that as a breach of a warranty and not as a good ground for treating the contract as repudiated. So the concept of repudiation is important, one that we would have dealt with in contract law generally. I think I took contract law recently. I may have taken that with some of you. So section 14 is important. Next one, section 15, implied undertaking as to title, is important. We're running out of time, so I'll just move through the next sections fairly quickly. Section 17, implied condition as to quality or fitness, is important. Now, this is where you might also need to consider the Australian consumer law, because the Australian consumer law provides for a number of guarantees. One of those is as to the fitness for purpose. And Australian consumer law, section 55, subsection 1, and ACL section 55 subsection 3 is important as well. So have a look at section 17 of the Sale of Goods Act. Now just bear in mind that generally, however, the rule of caveat emptor does apply in Queensland. And we know caveat emptor means, can anyone tell me? Latin for?
Buyer beware.
Yes, let the buyer beware. Thank you. So that generally applies, but it may be affected by the legislation, both the Sale of Goods Act and the Australian Consumer Law. I've mentioned section 55 of the ACL. Also look at section 54 of the ACL. Other sections in the Sale of Goods Act to consider. Section 20, dealing with the question of when property passes. Section 21, dealing with the rules for ascertaining intention. 26, revesting of property in stolen goods or on conviction of an offender. 27, the seller or the buyer in possession after the sale. 30, payment and delivery concurrent conditions. 32, delivery of the wrong quantity. 33, instalment deliveries. 36, buyer's right to examine goods. 37, acceptance. 38, buyer not bound to return rejected goods. And then 52, damages. 53, specific performance and equitable remedy. 54, those of you that need to go to evidence by, thank you. 54, remedies for breach of warranty. And 56 is the last one that I'll mention, which will wrap up for tonight, exclusion of implied terms and conditions. You've been very patient. Thank you. We've covered a lot of material and I've given you a lot of homework to do in the sense that I really do want you to look at these pieces of legislation carefully and work out a system for yourself of mind mapping and putting it together to answer a problem. Before we wrap up, are there any questions or comments? All good? All right. Thank you all. Yes, we'll see you next week. Okay. Bye then.